attorney and managing member for the Micklin Law Group. We are a law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices in Nutley, Montclair, New Jersey. Today is Monday, August 12th, 2019. I am in New Jersey, as I said, so if you're watching this at any other time or in any other jurisdiction, you need to make sure that it applies to your case or that it at least hasn't changed. This is my how-to series. I haven't been online for a few days. I was on trial last week, so I missed a lot of tips, so I'm doing this series edition a little earlier than I normally would. It's going to be probably a short one, but I think an important one. And it's about how to handle bonuses in support for New Jersey divorce cases. Bonuses can be problematic for many people. They're like investment brokers and things like that will often have a small base and a large bonus. Other people may be on a smaller company and have a larger income and a smaller bonus. So you need to know how to handle those as well as what options you have. So first is understanding what the courts will do with a bonus, because the problem with many bonuses is that they're speculative, meaning we don't know if you're going to get it next year or if they're going to be different numbers. And it's very problematic when a support number is based on income that included past bonuses when the future ones may be different. So first is, what does the court in New Jersey do with bonuses? And they will generally look to 3 to 5 years of average income. If there have been bonuses throughout those periods of time, they will take your average salary and base both alimony and child support on that number. And that's really where the biggest problem arises, because again, your salary and your bonus could be entirely different the following year. There's also issues to determine if the bonus you're receiving is for past services or future services, and that will also change the allocation in future years. But so let's say we're starting from the standpoint where the court's taking 3 to 5 years of income. What other options do you have? My favorite option is, if you're settling this matter, whatever your support matter is, and most of them do, you can agree that instead of utilizing the average of your past few years' income, you can agree to support based on your base salary and agree to a component of the bonus that gets added on top of that. Usually it's going to be a percentage. That's the easiest and fairest way for both sides to have a bonus-based support obligation, because that way, as the bonus fluctuates, so will the support. Because remember, I'm speaking mostly from the side of the person receiving the bonus, because it's speculative, and if you get a smaller bonus in the future years, you have trouble making your support obligations. But the opposite is true. If a person gets a larger bonus, the person receiving the alimony and child support doesn't share in that under the 3 to 5 year average. So the percentage base, it's really accommodates both sides, and I think it's the fairest of circumstances. Now, lastly, and this can be in conjunction with the percentage, you also want to agree to what is grounds for modification of your support. And this will be most important if you do not agree to the percentage and you go to a strict court average analysis of your past few years. You want to build in what will be a change of circumstances. And you could do this again on either side. Most importantly, if you're the paying spouse or parent, you want to have it so that if a certain percentage of your bonus is lost or withheld or decreases, that there be an automatic trigger for a review. You can agree to a specific number, which I think is best, and you can agree that that specific number is an automatic trigger to review. What you're each getting in a circumstance like that is, you're giving up, if you're the paying spouse, you're giving up the opportunity to allege any change of your bonus is a trigger. For instance, if you agree to 25% change in your payment, it's a trigger. Then if you got 10 or 15, you wouldn't have that ability and you'd still be paying on a higher bonus. But conversely, you can agree that a certain amount gets you an automatic reduction. And the reason you would want to do that, even though you're giving up what I just mentioned, is any change in your bonus doesn't guarantee you a change in your support. You have to file a motion with the court to ask that they review your support based on your change of bonus, and that be a reason to modify your support. Doesn't mean you're going to be successful. There's no preset determination in New Jersey that if you lose 10% of your income or bonus, that it's a child support review or a change of circumstances, or 20% is a change of circumstances. So you're at the mercy of the court. By agreeing in advance, you're giving up the lower modification numbers like 5 or 10%, but you're getting a greater one and a guarantee, which will save you time and money in the modification efforts. The receiving parent or spouse can also agree to just the opposite. If there should be a certain percentage increase in bonus, they will get an increase in support. And they're getting the same benefit. You don't know on the receiving end what would be a change of circumstances. And it's even worse when you're on the receiving end, you don't always have the ability to get future income numbers, tax returns, W-2s, because you have to allege there's a change of circumstances, which you may not have any actual proof to. It may just be based on a belief that a bonus is higher. So both sides are giving and getting something when it comes to settlement agreements and bonus components to support. But if you do it properly and you structure properly, both sides get protected pretty well. You reduce the uncertainty as well as the cost and legal fees and time and stress of trying to modify support, which can often be very challenging in New Jersey. I hope this information helps you. If it does, please give a like and share the video so others get to see it. You can subscribe so that you get notices when I go online. You can also leave comments, both, I think Facebook can do that with notes. If not, you can always message me. But on the live videos, you can always put comments. I will address them. If there's anything specifically you'd like me to cover, you can also email or message that to me, and I'll do my best to cover it. With that, I'm going to thank you and sign off until my next time on, which will not be tomorrow because I'm in meetings all day long, probably Wednesday the 14th of August.